Okay. So here's the thing.
Forced. Oh, no.
It could. Some people would like to see it overturned.
Yeah.
Probably a lot in Alabama. We know for a fact, yes, a lot in Alabama. That's a separate issue from the argument. There's a few common misconceptions about Roe v. Wade and what would happen if it were overturned.
Yeah.
Okay. All states place restrictions, or most states place restrictions, regulations on abortions outside of the federal purview. Texas, they wanted to ban abortion after 20 weeks, which Elizabeth Warren famously opposed because she's a moral lady. Everyone has the hill they're willing to die on. What's yours? The hill littered with dead babies. Yeah, it's the dying hill. That's why I thought it was most appropriate. The hill I want to die on is the dying hill. Colorado, 34 weeks. Virginia, 25 weeks. And these laws often make it, Bill, you probably know about this, Half-Asian Bill, they make it to higher courts. Yeah, so there's truth to that.
Yeah, they do. I mean, the case itself allows to have different restrictions based on the trimesters. That was the kind of fundamental, practical application of it. And so we have always, since Roe versus Wade, had limitations. And really, again, I think it goes back to your point, which is where if you really do think it's as easy as clipping a nail and it's as morally irrelevant as clipping a fingernail, then you should just be, you're probably more consistent to just say it should be allowed always.
Right.
And in these other states, essentially to say, that Roe versus Wade may be challenged. Well, Roe versus Wade is a very complex opinion that sets different types of restrictions at different trimesters. And it also has a certain basis in the 14th Amendment, the right to privacy. And so you can maybe parse some of those.
Can you explain that? Because that's something a lot of people don't know. They think that Roe v. Wade says there's a constitutional right to abortion. And they think they're in the Constitution, there's some interpreted right to abortion.
So what the 14th Amendment, which was the basis of the opinion, is saying that, yes, here you have the Constitution through the Bill of Rights, which says, or rather through an amendment, it wasn't in the Bill of Rights, but to say you can have a right of privacy, which that word isn't actually there, but it's interpreted as one of the rights that are broadly enumerated in the 14th Amendment. And then from that derivative right to privacy, you then have a further subderivative right that says that your body and being what you are going to do with your body. So, and I think intellectually, like at a very high level, a lot of people wouldn't understand. I mean, there's a lot of libertarian fans of the show who would say your right to privacy allows you to put in your body whatever you want, or to be able to do with your body whatever you want. So it's not like that entire spectrum of argument.
No, and by the way, I think that's a valid argument. I think libertarians, you say, not only do I think pot should be legal, but I think someone should be able to shoot heroin in the house if they want to. I think it's very hard to argue against that constitutionally. And it's a compelling argument.
But the difference becomes when, for example, you have a different heartbeat.
Right.
Yeah, you're hurting someone else in there, and where you draw a line, again, under the libertarian philosophy, you would draw a line when you're hurting someone else and those types of things. Yeah. And that's where you even on the question of what you have a right to privacy for, your right to privacy doesn't extend to what you can do to other people.
No, it's a really, really loose knot.